air raid alarm, we will have to go down to a shelter, but I think that we will not stop our broadcast because Zoom allows us to continue working in a normal mode. I'd like to say that last year, the European Commission approved a decision historical for Ukraine, with which it recommended to start the negotiation process for joining the European Union. And its opinion, the European Commission said that although Ukraine continues to face huge challenges caused by the full-scale Russian aggression, nevertheless, it continues actively moving toward the European Union and carrying out proper reforms. A number of recommendations have already been met, but there are still other recommendations that require important work. And one of such recommendations is about personal data protection, namely the need to adopt a new law on personal data protection. And this is the reason why we are here today, to draw attention to this important aspect of the reforms, to discuss modernization of the legislation, the two draft laws that have been tabled with Verkhovna Rada. It's the draft law on personal data protection and the other one on creating a national authority in this area. We would also like to discuss the existing standards of the Council of Europe and other international personal data protection standards to understand what the prospects are to introduce those standards in our life, and perhaps discuss a potential model of setting up an independent authority in this area. It's very important that we all together could consolidate cooperation between the stakeholders as regards the adoption of the new law, its further implementation, and I think that today's event will become the first step toward our common action in the further implementation of all the standards, modernization of our legislation. Allow me to give the floor to Dmytro Lubinets, the Ukrainian Parliament Commissioner for Human Rights, who should join us online. Mr. Lubinets, I'm very happy to see you because the Ombudsman's institution is one of our key partners in the area of personal data protection, because that's your mandate. The floor is yours. Thank you very much, Victoria. Good morning, dear colleagues. I want to welcome all of you at this forum of personal data protection, present scenario, future outlook, that we are organizing together with our permanent partners, the Council of Europe office in Ukraine, the Council of Europe that keeps supporting us and helping us. I'd like to apologize at once because I really wanted so much to be with you there physically. But unfortunately, because of certain processes related to returning back home our people from the Russian Federation and the temporarily occupied territories, I have to be outside of Kiev now. As it has been said, as Victoria said it, it's true that the objective of this event is to draw attention, to raise awareness for the central executive authorities, the civil society, the expert communities, in terms of modernization of personal data protection legislation, so we could bring it up in compliance with European standards. After the current law was adopted, 13 years have passed, and clearly new challenges have emerged related to the Russian aggression, to the development of our society, of the country, rapid development of technological progress, digitization, the use of AI, video surveillance and other processes. Clearly that now we are facing a completely new set of challenges, and this should be taken into account, and the law should be changed accordingly. The fact is that the use of those modern technologies in various areas, including security, medicine, and education, creates the need to have very clear legal regulation to protect the rights and freedoms of citizens and people in Ukraine. Separately, let me draw your attention to the fact that although one of the commitments of Ukraine as a candidate member for the European Union is to create a separate independent authority that will supervise personal data protection. However, even after such an authority would be set up, the National Commission in Ukraine, still the Ombudsman's institution will still keep parliamentary control over personal data protection because it's been established so by the Constitution, and our institution will continue monitoring visits, educational work, legal work, and most importantly, will respond to the applications of Ukrainian citizens if their rights are violated. We believe that the Ukrainian Parliament Commissioner for Human Rights should become a kind of a platform, a permanent platform in the area of personal data protection. We submit new initiatives such as having awareness campaigns. It's true that in our work we often face situations when, unfortunately, even many top managers of the executive authorities or local governments do not exactly understand what personal data protection means. They don't really understand how they have to respond to it, how not to breach those rights. That's why we believe that we still have to continue this awareness work, awareness raising in the country. Now, as regards the draft laws, I'm very happy that we have MPs with us because it's the function of the parliament to adopt laws, to change legislation, and it's very important that the MPs would be directly engaged in the process of discussing the ideas and implementing of all those recommendations that will probably be made today, be made by our participants today. I would like to once again say that our institution and I am personally absolutely open to any initiative. We are ready to continue bringing up this issue. I believe that we urgently need to take this road and to adopt the final laws, to set up a national commission. Yeah, we can discuss how it will be launched, maybe after martial law or even during martial law. That's to be discussed. But it should not even be discussed, the idea that this commission should be set up. We have to have it, and it should start working in Ukraine. Today, our office, as regards personal data protection, is represented by representative Lina Derkachenko. And I believe that in our department, in our institution, we have a team of professionals who are ready to answer any question and take into account any recommendation of yours. I want to wish you all fruitful work. Once again, I want to thank our partners, the Council of Europe office. Thank you really very much. We will suggest some new initiatives for you, and I hope that all of them will be supported by our partners. Thank you very much. Glory to Ukraine. Glory to heroes. Thank you, Mr. Lubinetz, for your optimistic speech. I think that together we will be moving this rock toward European standards and the legislation. Thanks to Taras, who is next to me, who's telling me everything will be fine. We will overcome all those obstacles. Now I'd like to give the floor to Lily Danegat-Bosler, the Deputy Head of the Cooperation Programs Division, Department of Human Rights, Justice and Legal Cooperation Standards, Director General, Human Rights and Rule of Law of the Council of Europe. Lilith, please.
Thank you very much, dear Victoria. Nice to see you also there in Kiev. I hope you see me well, you hear me well. Dear colleagues,
Дуже добре бачимо.
We can see you very well. Thank you.
Thank you. Dear partners, dear participants, dear Ukrainian Parliament Commissioner for Human Rights, Mr. Lubinets, nice to see you at least online today. Dear Head of Operations of the Delegation of the European
Виключений мікрофон.
They say your microphone has been muted.
Вибачте, будь ласка, щось сталося.
Right. I'm sorry something happened to the connection. I understand that they are trying to correct it, and I think that Lilith would join us later, and our colleagues will tell us. We can continue in the meantime, right? Well, I think that as soon as Lilith has connection, she is back with us. Let's try again.
I am there. Can you hear me, Victoria?
Так, нормально. Сподіваємося, що все вийде.
Yes, right. We can hear it now. Let's hope everything will work.
Thanks. Okay. I don't know where I was kicked out from the meeting, but by our system. I was just saying that the Council of Europe will continue its efforts to support Ukraine during this time of extraordinary challenges. And that the Council of Europe Action Plan on Resilience, Recovery and Reconstruction 23-26 aims to reinforce the country's institutions through common European standards and to help Ukraine undertaking the reforms required for its future membership of the European Union, following the 23 December decision of the European Council, which opened accession negotiations for Ukraine. In May 2024, our institution, our organization, the Council of Europe, will mark its 75th anniversary. It's a significant milestone to reflect on the achievements of the Council of Europe in establishing a common legal framework and promoting standards in human rights, democracy, and the rule of law, which extends to data protection, where the Council of Europe has played a pivotal role for over 40 years through its Convention 108. That convention, being the first legally binding international instrument in the data protection field, continues to adapt to the new realities and then therefore offers the enhanced level of personal data protection vis-a-vis state security or other possibly conflicting interests. The convention was modernized then, and the Convention 108 Plus addresses the ever-increasing challenges of a digitalizing world in order to build a space for transfer of data while securing human dignity, which makes Convention 108 Plus a unique and universal tool yet to enter into force and be ratified by our member states, including Ukraine. The protection of personal data is not an autonomous right among the various European Convention rights and freedoms. The European Court of Human Rights has nevertheless acknowledged that the protection of personal data is of fundamental importance for a person to enjoy his or her right to respect for private and family life, home, correspondence, as guaranteed by Article of the Convention. The reform of data protection area is quite complex.
Даних є доволі складною і широкомасштабною, хоча
Specifically, it is important of emerging dimensions of ongoing war. Support our organization, Ukrainian authorities efforts in this direction, activities. Just find that 2 draft laws, personal data protection and in the field and access to public information through expertise provided by the Council intercultural discussion. And the last word now rests with the Ukrainian government, as developments have been meeting for legislative being asked, but not. I would particularly Human Rights Commissioner Lubinetz and his institution. They are tasked with the responsibility to monitor the protection of the and access to public information. In the current war context, heat powers and of the institution. Let me conclude, dear colleagues, confirming that all of you can do implementation of the action plan in Ukraine through our cooperation programs, activities to build culture, privacy, human dignity, technological. As I already said, this extremely challenging are working now. Thank you very much and stay.
Thank you very much, Lilith. Today we have to me, I member of parliament of the Ukrainian Parliament's Commission. We will definitely overcome all those problems, and but also sure does. Thank you. Words how to proceed, as we do not have any more official persons like to proceed to the I'm sorry, but his microphone is on. In 2019, when we started on changing the law, the objective was to bring it in compliance with European standards and to get to that single digital space. Now, during the scale military, the issue of personal data and data management, there's some meaning and a more important one. Creating, developing the functions in the used population or as weapons for God. That's why it's important to start this kind of material discussion about confidentiality, protection of personal data during the war, and how international community to create new legal mechanisms and instruments that could better protect the digital rights during armed conflicts. Give Taras and Parliament Committee on Social Policy and Protection of the Veterans' Rights. And I'm sure that Taras will tell us a little bit more about the prospects, the outlook about how we're going to keep moving ahead. Good morning, dear participants. Well, first of all, I'd like to suggest a minute of silence to respect all those who have died at the Maidan, all the women and men thanks to whom we're here today, the capital city of Kyiv, Ukraine, we can live our life and discuss these draft laws.
Дякую.
Thank you. Now, about my speech. Well, you've heard the Ombudsman, the Council of Europe, all of them place their hopes with the Parliament. And I have a feeling that only they believe in this draft law and that it would be adopted and are supporting it. Why is this happening this way? Because our bureaucratic machine, the system, does not want to change, unfortunately. This draft law has no emotions. It is well structured, legally balanced. But now during the war, when we have to vote for difficult laws on recruitment, on conscription, on information protection, this draft law is not a priority. If we're talking about emotions, but talking about logics and protection of our people and of our statehood, and about how the enemy operates information, we can say that this draft law acquires a completely different significance. Unfortunately, now, well, I can state the fact that most of our colleagues, members of parliament, do not yet understand the essence of this bill, and they are not ready to discuss it. And if we discuss it in the hall, most probably it will be only in summer of this year. We hope that thanks to such events, and I really want to thank the Council of Europe for bringing it up so that we can discuss it once again. We're discussing it with ministers, with the top leaders of the Verkhovna Rada, and therefore we logically try to persuade them to explain that protection of every one person's data is extremely important during the war. While the enemy can use the data that is not properly processed, and unfortunately the Ombudsman does not have the powers and the resources. Well, even if they had the powers, they don't have proper technical resources to carry out actions, for example, to block improper data processing. We can all see how all the networks, telecom, store networks, they gather our personal data. As a person who has gone into this process quite profoundly, I'm a co-author of this draft law, and I want to thank all of my team that has drafted this law. We've discussed it for a long time. And I, as a person who, when I get a question at a food store, please give me your phone number, you will get a discount. And I thought, okay, what about the personal data protection declaration? They look at me with very surprised eyes. We're not doing anything. We're not processing it. We're just only going to give you a discount. We're not going to do anything with this data. That's what they tell me. But that's an individual issue that should also be resolved, because in fact, that's just about personal data processing and a possibility to give every person one's individual control of where this data need to be processed and where one would not want it. Today, no Ukrainian has this possibility. I cannot turn anywhere. So, for example, Dnipro M company would not call me every month and tell me that they now have new drills, electric drills. And there is the other side of this problem, and I'm facing it in my practical work. I work a lot why I have moved to another committee. I now work with the war veterans and working with the issues of their rehabilitation. And what I face is that we need broad data processing, and we need very broad masses of data to make well-balanced decisions that will affect our budget and its distribution between different entities, and to effectively use it so that we can provide effective assistance to the people. We need to understand we have limited resources, and only by effectively using them, it can lead to proper quality of the services that we provide. But we do not have proper analysis. Yes, a lot of data is gathered on paper. We still have card files, although someone has created us, the authors of this draft law, someone told us that we no longer have card files. In the army, we still have them, only that. And old maps, and yes, all of it is a problem. But in the second year of this full-scale war, having our limited resources, we cannot afford it anymore. Yes, we have to speak about very effective IT protection, but here it's still the issue of decision-making about how this data is gathered, disseminated, and shared by different entities, and it's of a completely different level now. Because now, for example, information on delicate data, they are asking us to make it, in such a format that we could share information about a soldier or an officer who's going to demobilize, who would go to one's community. And I, as an expert related, first of all, I need to understand how it complies with personal data protection, human rights, because maybe he or she doesn't want the community to know all that, and how we can protect this information so that the enemy would not get all the information about all our wounded soldiers that will be shared with all the communities of Ukraine. On the one hand, what worries us, we are concerned about those people, because the communities have to be concerned about those war veterans that are going to come back, to welcome one with respect, to prepare, facilities and everything that this war veteran needs. On the other hand, we have to provide data protection on the national level. That's why, in fact, there are many issues that emerge. I believe that those draft laws should have been adopted 2 or 3 years ago when we drafted them. They were relevant at that time. Now they're once again losing this relevance because of artificial intelligence that is already affecting the laws of other countries. We're studying how personal data protection in other countries affects blocking, for example, of AI. By adopting this law, may God help us, we will once again have to sit at the table to develop new changes, new standards, or design them right now related to AI. So, in fact, there is a lot of work we have to do. Unfortunately, this draft law is not emotional, let me say it again. There are no participants of this event that will come to the Verkhovna Rada with posters and start demanding that the law be adopted. No, we're working in a kind of a small lobbyist circle that is trying to promote this bill so it would be voted. Now it had been supported by our committee. We insist that the law on Ukraine at the National Commission should be supported by the committee in the first reading. About 18 pages of different amendments have been developed to this bill because we have taken into account the ideas of the banks, of telecoms. Very many amendments have already been drafted. And now we hope that we will make sure that this draft law is submitted to the hall and we will vote for it. And I will try to do everything so we get 226 votes for it. Thank you. Thank you, Mr. Tarasenko. It's true that this is a 3-year-old fight that has become a kind of a hobby for many of us, for the initiative group that is working pro bono to finalize this draft law for 3 years now, and this group is still intact. We are still united by this idea. We all want to get to some kind of, yes, we even have family friendships. And every day brings us some new challenges. And the issue of artificial intelligence, we have not even touched it in the draft law text, and we will probably have to re-update it and to... No, Leila says no, we should not. She says we will vote for it the way it is now. Okay, I'd like to now proceed to the presentation of my colleague, Peter Kimpian, who is Secretary to Convention 108, or as it is completely called, on protection of physical persons because of automated processing of personal data. As it has already been said, as Lilith said, this is the only binding legal document for protecting the right of personal data protection that is open to any country of the world. The Ukraine has ratified this convention. It's a member nation of the Council of Europe. That's why it is obliged to bring its law in compliance with the convention. Peter, very happy to see you. And the floor is yours. Thank you.
Thank you so much. Thank you. Good morning to everyone. First of all, let me thank the organizer for having me. And also let me commend you for all your efforts you are making in these extremely difficult situation, difficult times. There are no words to describe what we felt when we learned the war aggression against Ukraine by the Russian Federation. And we still remain under the shock. So me personally, I would do anything that I can to support this process, which I already commanded publicly a lot of times. I spoke regularly about the Ukrainian efforts of bringing to life a data protection law, despite the difficulties, despite the atrocities in the country, and also I try to highlight why it is important. I understand, and this process is not easy, such as every process. It's to adopt a data protection law. It's not easy in any country, even during peacetime. So, in my short intervention, I just wanted to give you some more elements maybe to reflect upon, next to, again, the reassurance of my full support for the process, anything you might need in this respect in terms of cooperation or any other support. You can be sure that I do my utmost best to provide you. But again, coming back to what has been already done, I cannot only thank you again and commend you for the efforts. I have seen the draft. It is really going into the right direction, but it not only has an expert meaning, so for a meaning for experts or a work on a substantial level, because with this draft you are not only making a testimony of your commitment towards human rights, rule of law, and democracy that the Council of Europe stands for, which goes even way beyond that Special Representative Borrell said yesterday in Kiev, that protecting the European security. You are protecting the values of the Council of Europe. You are protecting the values the Council of Europe was founded upon after the Second World War. Coming to a political level discussion, because I understand that among you there are some political representatives, member of Rada. So it is very important that there has been a political determination that Ukraine has to join the European Union, and very rightfully so. And I'm sure that my colleagues already told you that the Council of Europe will, in many way or in all the way possible, support this process. For data protection, it is also an important step, and there is also some level here for at more practical level to understand, because in the EU, the protection of personal data is a very detailed area, and there is a very famous regulation, the GDPR, that you may already know, which is not easy to implement by any country, but even the member states of the European Union. It has some challenges, and there will be, I'm more than sure, negotiations during the accession process on this chapter. To facilitate this, however, it has been proven very beneficial and also helpful for countries that have already signed and ratified Convention 108, and in particular the Convention 108 Plus, because of a recital that the GDPR has, namely the recital 105, which requires the EU Commission to take into consideration the partnership, the membership of a country to Convention 108 Plus. For the EU accession process, and this is not only for Ukraine, it has already always been the priority, and if I can say so, strategy for the European Union to recommend countries to first join Convention 108 Plus, then start negotiations for adequacy decision, but in this case, an accession procedure. This is an important area, I believe, an important political level determination that the country can take into account. But parallel to that, there is not only political level considerations, but also the issue of data transfers. To transfer data abroad today, and especially or increasingly so in the European Union or countries belonging to Convention 108 Plus, you will have to have a legal base. And for this, Convention 108 Plus is an excellent instrument, because it not only enables country to send data on a bilateral basis, so between European Union and Ukraine, for instance, if once an adequacy determination would be reached, but to currently 55 parties, and in the future with the new convention to 38 parties to Convention 108 Plus. On the top of that, we are also working on instruments that even before the entry into force of this convention can allow mainly businesses and economic players to send data based on this convention using the modular contractual clauses that I also recommend you to take into account. But the data transfers not only happen for or in the private sector. There is an increasing need, and I believe for Ukraine, it is more than evident, for sharing data for public security purposes, including national security and also military. The EU instruments doesn't cover this area. Only international convention, not only for data protection, but those fields is the Convention 108+. So if you are looking for facilitating exchange of data between law enforcement authorities, between national security authorities, or even military intelligence, I believe Convention 108+ has a great future, and you can also rely on that. And I'm also coming to another considerations that are more of a legal nature. Ukraine and the Russian Federation are both party to Convention 108, the current one, which means that if a country doesn't make a derogation from the scope of the current convention, that it needs to apply the convention for the processing of personal data, irrespective of the sector. We know that the Russian Federation, even before the war, has its own interpretation of the implementation of this convention, and we was very vocal and also went on public for trying to remedy them. But during the war, I believe that this convention should be also implemented and should also be adhere to and comply with. And falling to that could also give rise to claiming the damages and the harm done by the non-compliance. And I'm coming here to the registry that has been created for the purpose of this unfortunate war, and to take account of the illegal and harmful action of the aggressor. We will assess illegally the possibility with my colleagues at the registry how Convention 108 can serve for this purpose, but for the sake of consideration, for the sake of the discussion today, we can already maybe start this discussion. And I'm also coming to another aspect, the military aspect, because unfortunately this issue didn't came up first time between Russian Federation and Ukraine. We already had to start assessing this during the war between or atrocities between Armenia and Azerbaijan, and we found that there is very little till date on this in academia within the Committee of Convention 108 or even within the military to rely upon. I had an immense chance and pleasure to meet Deep Channa, the director of Diana of the NATO, with whom we agreed to make a strategic partnership to develop this area, how to protect personal data during wartime or for military purposes. Why? Because also in NATO, they having, and in Diana, they are having an emerging discussion, which unfortunately also didn't start it now, that even during wartime, human rights, rule of law, should be respected and should be adhered to, because otherwise even military operations can create more conflict than they resolve. It is increasingly important that we have a guidance on that, and for this, Ukraine can be an excellent partner, also based on Convention 108 and its participation to the committee, or based on the membership of the Council of Europe. And I will finish by the new technology. Somebody mentioned AI. We are currently, as you know, and my colleagues in the corridor are very busy drafting for the upcoming plenary meeting of the CAI, the Committee on Artificial Intelligence, a framework convention on 108. Of course, I will not predict what will be the text adopted, but there is no discussion whatsoever among member states or at the Council of Europe that when it comes to the processing of personal data, Convention 108 will be, Convention 108 Plus, will be the instrument to rely upon, also for the purposes of the processing of personal data through artificial intelligence techniques and technologies. When it comes after that, of course, it will be an international framework convention, which we also invite you to consider adhering once it is open to signature. But for data protection purposes, we have already a solid mechanism that you take already part in, and I commend Julia for its participation in the committee of Convention 108. I really recommend you to step up on the efforts for making the ratification of the new convention possible for Ukraine, because I believe it has a political, legal, and military consequences and considerations. And you can be sure you have all our support for that through my colleagues or even directly to me. Thank you so much for your attention.
Дякую, Пітер, за
Thanks a lot,
акцентовану увагу до конвенції.
Peter, for focusing on 108 Convention and updated version of 108. GDPR is better known in Ukraine, but Peter outlined the positive features and prospects for Ukraine
Це, мабуть, що дійсно
by using 108 and
мають бути
benefits it brings, including military, while it is political decision that should be taken as to the standards, as to the ratification of the protocols, and as to the overall work of the related agencies that are developing the security service of Ukraine. We have representatives of the agencies today, and I think that's a good chance for them to think through how we can jointly cooperate to this end, and where the Council of Europe could be useful in terms of expert assistance. Let me give the floor to Yulia Derkachenko, representative of the Commissioner for Information Rights. Julia is going to outline the state of play in Ukraine. Good morning, dear participants. Could you please put up my presentation? Let me tell you about the work the Commissioner is doing on data protection under the law of Ukraine on personal data protection. It is the Commissioner, that's slide 3, that has the mandate to protect personal data during the war. Under the law on personal data protection, the competence on complying with the legislation on personal data protection is vested with the Commissioner for Human Rights. Therefore, the Commissioner considers complaints in case of breach of personal data, verifies the breaches, issues respective documents confirming that, and involves in information awareness campaigns. So if you look at the data 22 and 23, so the number of the violations in 2023 has increased a lot. The breaches include unlawful personal data protection, the right to access to information, the way the processing is done. Sorry, but that's PDF format that you put up. We need the presentation mode. Apologies for technical issues. Thank you. So, you can take a look at this slide. We undertake verification in 2023. We conducted 101 verifications of the breaches of personal data. That included the inspection of the public authorities, oblast departments for education, pension offices, the postal offices, operators, railways, and trade chains. We received 274 complaints that required recommendations as to further action on personal data protection. On a daily basis, we receive regulation from state authorities to get approval on, and when it comes to any or all of them, we provide recommendations as how the personal data protection regulation could be duly applied. Despite shelling and war issues with the electricity supply, the Office of the Commissioner is duly performing the mandate as to personal data protection and respectively conducts all necessary activities and undertakes respective measures. In 2022, we issued 3 protocols in the instances of the personal data protection violation. In 2023, we issued 9 protocols confirming personal data protection violation and administrative protocols. So we referred the protocols confirming personal data protection violation to court. So here is the most typical violations of the personal data protection. The first is the stock of the operations on personal data processing is not done. So the procedure for deleting of the personal data protection as well as the period of storing them is not developed. The legal grounds for personal data processing are not identified. The subject of personal data is not informed. There is no procedure in case of unauthorized access to personal data. The damage of technical equipment and devices and contingency situations. All these challenges encourage the Commissioner to provide recommendations as to personal data protection, and all these recommendations are available on the website of the Commissioner. The most recent recommendations were developed with respect to AI in human rights protection. So the Commission is involved in human rights enforcement and protection with the use of AI, and jointly with the Ministry of Digital Transformations and jointly with the Parliamentary Committee for Digital Transformations, we have been promoting this issue and started drafting respective legislation on the use of AI. Ministry for Digital Transformations developed the roadmap as to further actions in personal data protection and human rights protection with the use of AI. So all these issues are really important for us to work on, and the Office of the Human Rights Commissioner is actively working on them. Council of Europe is actively supporting us, namely that's the project supporting implementation of the European human rights standards in Ukraine. And we have been also actively working with other international partners, engineering of public services, digital Ukraine, GIZ. So there has been an active work going on, and we are trying to tackle the most pertinent issues, and we do hope that legislation on personal data protection is adopted, and we'll have the National Commission for Personal Data Protection and Access to Public Information set up in Ukraine. As Peter said, Human Rights Commissioner Office is working also in the Committee on Convention 108. Apart from that, our office is engaged in experience exchange and keeps improving our knowledge. We went to Poland, Spain, and Georgia to exchange our experience and learn more. We are engaged in different online and offline meetings on a weekly basis. These are the conferences on personal data protection, AI, and other important issues. I believe that to be engaged in high-quality information awareness campaigns, we need to be properly professional, developed, and train our staff respectively so that they are engaged in personal data protection and the use of AI. Then the Омбудсман Office of Ukraine should be the platform for knowledge sharing and education and information awareness campaign. Why? Because following the adoption of legislation, we'll have to train 1 million of representatives of public institutions as to all the issues, and it is going to be our office who is going to be the focus of these trainings and education campaigns. So information awareness and education comes as a priority. That includes issuing protocols and sanctions in case of the breach. And that's our mandate, and that's our discretion powers. Why? Because the Commission is trying to focus on remedying the situation first. We identify the breach, we provide recommendations, we allow for the public authorities and local self-governing authorities and other organizations to have some time to remedy the situation, and only in case of the recurrence we issue respective protocols and or documents, and then the sanctions are imposed. So in the near future, nothing much is going to change in this aspect, and if there is a National Commission on Personal Data Protection is set up, it doesn't mean that the fines are going to be imposed immediately. So we'll have the procedure in place, and that's going to stay. But anyways, we are going to focus on information awareness and education to start with. But then in the future, I think that the work in this area is going to be properly arranged, and we'll have less and less violations there. Talking about education and information awareness, let me focus on the fact that Council of Europe the work with the Office of the Commission developed a special course on personal data protection in 2021. That's a basic course as well as advanced course that is confirmed by respective certificate. The training course is available on Adera platform. That's the course that is called Personal Data Protection. It's very good interactive course that explains very complex issues in an easy and simple manner. There is another additional resource. We have Help course. It's very popular with everybody. That allows for self-learning and tutor-supported courses. And there on their website, well, that's Council of Europe website, but you have to access Help course, and you can find lots of different courses on human rights protection as well as privacy. That's under Article 8 of the Convention on human rights. Let's move on to session 2 of our event, and let's talk about modernization of the data protection legal framework, about institutionalization of the personal data protection. And let me give the floor to Diana Shinkunene, Council of Europe expert, Director of the State Data Protection Director of the Republic of Lithuania. Diana, for a long time, for 3 years, has been with us, working jointly, and she was engaged in drafting expert opinions and analysis that served as the basis for drafting legislation. Diana drafted a legal opinion with respect to draft law on personal data protection as Council of Europe expert. And, well, she has an extensive knowledge and experience in this area. She is also a director of the agency that is to be set up in Ukraine, hopefully. So over to you, Diana, and the floor is yours.
Thank you, Victoria. Good morning to everybody. Should I share my slides myself, or maybe they will be shared by organizers? Maybe I could do it myself.
Да, сама. Краще самі, якщо можна.
Could you show it yourself, please?
Okay, I will try to do this. Just a moment. Yes, now just I need to start for the first one. Okay.
Нам все видно. Добре. Щас розширю.
Is it
We can
okay?
see it well. You can see it well? Yeah, we'll just
Okay.
need to put it in the presentation mode.
Okay, hope that this is okay. The slides are moving, yeah?
Так,
Because
секцію.
Yeah.
I see like in presentation mode, and hope that the same is in Kiev. You can also see them in the same way. Okay, before starting my presentation, I'd like to reflect some things that were already said by previous speakers. Yes, I would completely agree that preparing and discussing the draft laws with various stakeholders, it is really a huge job, a huge work that already has been done. But the next very important and challenging step is adoption, but not only adoption of this law, of this legislation, but also implementing this into practice. And today I will talk a bit about, let's say, very basic things about the right to personal data protection, about the supervisory authority, but also I will try to reflect what is going on at EU level right now about personal data protection, what direction do we have right now, and what to prepare for Ukraine during the negotiations with the EU. Another important thing that was said by Julia is that the Data Protection Supervisory Authority is not only the authority that is aimed for punishing companies. I would stress and I would contribute to the idea that one of the main functions of the supervisory authority is also raising awareness, giving recommendations, promoting personal data protection. So you should not be frightened by this role of punishing fines, issuing decisions, and so on. So this would be my main reflections. Now I will start my presentation, as I said, with some very basic things. So, of course, first of all, with the Convention 108 plus. Okay, now it's okay. So, as it was already said, the Convention 108 plus is a very unique document, international instrument, I would say, because it is the first legally binding international instrument in the data protection field, and it still remains, I would say, the unique worldwide document, accessible and open for joining for every country in the world. You would not find any other international instrument in personal data protection field of such a general and encompassing a lot of things in nature. So the purpose of the Convention 108 plus is to protect every individual despite his or her nationality or residence with regard to the processing of personal data, and thereby contributing to respect for human rights and fundamental freedoms. Here we see human rights and fundamental freedoms in general, in particular, of course, the right to privacy, but we will see that personal data processing relates and can make influence to many of other rights and freedoms of a natural person. And why the Convention 108 plus is also unique, so that it is applicable in the private, in the public and private sectors. And here I also would like to highlight the thing that Convention 108 plus is also applicable to the processing of personal data for the national security purposes. In opposite, we will see that the GDPR is not applicable in this area. Talking about personal data and privacy protection in EU, I could say that EU legislation in principle reflects and regulates personal data protection in more detail in comparison to the Convention 108 plus. But of course, here we would not find, let's say, any conflict, anything like that, because EU is just following Convention 108 plus principles. So the main legal acts here are, of course, the General Data Protection Regulation. We also have Law Enforcement Directive, which regulates personal data protection in the law enforcement sector. Also, we have, let's say, quite specific directive regulating privacy in electronic communication sector. If we look at 35 EU acquis chapters, so of course we would see that the data protection is relevant to many of them. I don't know, let's take statistics, let's take information society and media, let's take justice and freedom area, and many other areas. Everywhere we can find personal data protection. That's why, again, I would like to say that adopting these laws and making them work in the practice is very important. And just it is also I would say, of course, I would be very happy if we can adopt the laws and to make them work tomorrow, but normally it is very difficult to make such things. And as I know what was the practice in Lithuania and what it still is, I would rather say that implementation is quite challenging thing. So, as I said, a bit about privacy protection in EU and where we are right now with the GDPR, let's say. And when preparing my presentation, I looked at the contribution of the European Data Protection Board. This contribution is saying to contribute to the report on the application of the GDPR and the Article 9097. This report will be prepared by the European Commission following this, namely this Article 97 of GDPR. And some of the ideas, some of the highlights made by the European Data Protection Board. So first of all, the EDPB, the board said that the application of the GDPR in the first 5.5 years in principle has been successful because the GDPR serves as the model of harmonization of the rules, of the data protection rules across the EU. With the GDPR, disappeared these differences between national legislations, and the GDPR is often considered as a model by countries outside the EU. Also, the EDPB, as such, has consolidated its position as the EU body in charge of ensuring the consistent application of the GDPR. Because again, we have national data protection supervisory authorities, and we have the GDPR as the legal instrument which is applicable in all the EU, and that's why the role of EDPB as the body which unifies the which unifies the supervisory authorities of every EU member state. Its role is very, very important when ensuring the consistent application of the GDPR. During this period, the EDPB issued more than 200 various documents like opinions, recommendations, and others that were aimed to ensure this the consistent application of the GDPR. And also, the second thing is that the EDPB has a unique role in the EU, as it also provides the dispute resolution mechanism under the GDPR. But just imagine there might be international cases where several supervisory authorities are being involved, and in case they cannot find the consensus, then the EDPB has its role to set up these disputes. And so far, 11 such kind of decisions already were issued. Also, what is important, the EDPB considers that the existing tools in the GDPR have the potential to achieve a goal of effective and efficient cooperation between data protection authorities, leading to a common data protection culture and consistent enforcement practices. But however, this international cooperation among different authorities, it's also not an easy task in the practice. So the European Commission raised an initiative and submitted proposal for a regulation of the European Parliament and of the Council, laying down additional procedural rules relating to the enforcement of GDPR. And this new regulation will set up procedures concerning international cases where not only data protection supervisory authority is involved, but when the case concerns the residents of several EU member states. So, saying this, just I'd like to show you and to explain how complex is the GDPR, but not only the GDPR, but its implementation in the practice. How many efforts it requires, not only from single supervisors, but also it requires setting up these let's say, a bit higher rules that would let to apply all these rules in a consistent manner. Also, again, just for you to show how many efforts have been already done in order to make this international cooperation and, let's say, solving these international cases to make this process more smooth. So the EDPB recalls in this document that additional cooperation actions in the area of GDPR enforcement are essential in order to ensure a consistent application of the law. And in 2022, the Vienna Statement was adopted. It relates namely the enforcement of the cooperation between data protection supervisory authorities and sets up, let's say, several possible ways how to cooperate in more smooth way. So if I could name just some of these things, there could be a single complaint template for every member state, expert group which also contributes to EDPB work, also making some let's say coordinated enforcement actions and other things. Let's say maybe the last but very important thing is that the GDPR fully applies to emerging technologies and provides rules which foster innovation while at the same time ensuring the protection of personal data. Again, nowadays at EU level, we have a lot of new initiatives. One of them, proposal for the artificial intelligence regulation, but we also have Data Governance Act. We also have Digital Markets Act and some other legal acts that also relates very closely to personal data protection and to the competence of the supervisory authority. So here I'd like to remember myself and to remind you this paragraph, not subparagraph, but recital 4 of the GDPR, the first sentence of it, which says that the processing of personal data should be designed to serve mankind. I like this very much, and I'm sure that processing itself should serve not only for the interest for some companies, even for the natural persons, but the purpose should be higher. And these new legal acts, in my point of view, in some sense reflects this idea of GDPR. And the EDPB also said that all these new trends are fully met by current GDPR rules, and that at this point of time, there is no need to revise the GDPR. Of course, we will have some challenges, some new things, but still we have possibilities to live with the current rules, just to making some steps how to apply them into practice. Okay, I see that I exceed my time, so just several words about supervisory authority. We already know that ensuring the effective protection of individuals requires supervision of compliance with the provisions of Convention 108+. So the independent supervisory authority is necessary, but the Convention also says that more than one authority might be needed and might be established to meet the particular circumstances of different legal systems. Here I could also say, for example, that as regards national security area, it is, I would agree, that is quite specific one. And for example, in this field, of course, there might be a specific supervisory authority, which of course should meet the criteria set up in the Convention 108+. And as I said, the main thing is that the supervisory authorities shall act with complete independence and impartiality in performing their duties and exercising their powers. Again, for reminding you two very, very important blocks regarding supervisory authority. So, as I said, independence. So, this authority should be free from external influence, neither seeking nor receiving any instructions from outside. Also refraining from any action that is incompatible with the duties of the members of it. The authority must have sufficient resources, including human and financial, and it should have ability to choose and have its own staff, which must be subordinated exclusively for the head or to the head or to the members of the authority. And the separate public annual budget, which normally it could be a part of the state budget, but not a part of any other state institution. And the powers, I will be brief: investigation and intervention, issuing decisions with respect to violations, engaging in legal proceedings. Also, consultations must be held with the authority on proposals for any legislative or administrative measures. And as I already said in the beginning of my presentation, last but not least, promoting public awareness. And I will finish my presentation with the recent European Court of Justice judgment, which was adopted on 16th of January of this year. And why this case is interesting for me, because it concerns supervisory authority, and namely its powers with regard to the area of, let's say, of national security. And the court in this judgment said that, GDPR does not apply to the processing of personal data in the course of an activity which falls outside the scope of EU law. In this case, just for example, for safeguarding national security, or the activity which can be classified in the same category. But the GDPR has the sole purpose of excluding from its scope the processing carried out by state authorities in the course of, namely, of such activities, but not going somehow broader. And the court also said that the fact that the controller is a public authority whose main activities to safeguard national security is not sufficient to exclude from the scope of the GDPR the processing of personal data that this authority carried out in the course of its other activities. And in this case, this particular case related to Austria, again, let's say, to the state with quite deep data protection traditions, but in this particular case, this public authority also carried out the processing. Let's say this processing concerned making personal data public on the website of this authority, and the Court of Justice said that even this public authority is set up for safeguard national security, but this kind of processing, making personal data public on the website, which normally does not relate to this main purpose or to the processing for national security. So for this kind of processing, the GDPR should be applicable. And the other very important thing, the court said that the limitation of the competencies resulting from national provisions of a constitutional nature is not permissible. So the court approved, not the first time, of course, primacy and the direct effect of EU law. So that would be my main ideas today. I'd like to thank you for your attention and hope that we will have interesting discussion today.
Дякую, Діана, за таку детальну
Thanks a lot, Diana, for really very detailed presentation that outlined the scope of tasks Ukraine is facing. We are just at the beginning of this path, so the only thing we can expect is just this path could be easy because we have European partners that have done this bit and they have acquired experience, and that would make our process smooth with their assistance. But the new challenges the EU countries are facing are going to be the challenges for Ukraine too. Our
великої кількості людей, особливо
discussion attracts attention of many people, including politicians, and we have
народний депутат України,
member of the parliament of Ukraine, Alexander Avdiyenko, an expert on cybersecurity, and he represents the Parliamentary Committee on National Security and Development. Over to you. Good morning. Glory to Ukraine. Glory to the heroes. I joined the Parliamentary Committee on Digital Transformation, and I was the deputy head of the Parliamentary Committee of Digital Transformations, and I did a lot jointly with my colleagues to digitalize our society. With the full-scale invasion of Ukraine, I had to join the National Security Committee to focus on cybersecurity, cyber defense, communication, etc. At the same time, I remained focused on electronic communications and metadata issues. And I would like to briefly mention that we are facing historic momentum at the moment when there are a lot of foreign companies and organizations that have their back offices on the territory of Ukraine. We have a huge exchange of data with limited access, and Ukrainian business at the same time is geographically located in other countries, and foreign clients of Ukrainian business do have an effect on the way the data is being processed and stored. That's why modernization of Ukrainian legislation and personal data protection and bringing this legislation in compliance with the EU standards is becoming our primary task. Unfortunately, effective legislation does not cover lots of issues that we are facing in practice. That's why, and let me stress that we need to immediately change and update our legislation. And I do hope that the colleagues in the Parliament will support the draft laws. Unfortunately, the previous discussion was not supported by the Parliament, though we promoted it forcefully, and I rely on the support of the experts that present at this event. I really hope that following this discussion, the respective parliamentary committee will have the answers to the questions raised, and having improved the draft laws, they will be submitted for the vote in the parliament. On my part, I can reassure you that you'll have my full support and lobbying. Maybe it's not the good word, but I'm going to lobby the draft law. I will be involved in finalizing the draft law to make sure that they are supported and voted for in the parliament. Thanks a lot for your efforts. Glory to Ukraine, and we'll persevere. Thank you, Alexander, for your support and for the lobbying of the legislation. That's very important for us. I'm sure that the Committee on Personal Data Protection is going to take on board today's discussion. Lilia can confirm that both draft laws have been improved and they are going to be ready for the first discussion and for the second reading, but they have been modernized and updated. A lot of work has been undertaken in summer. We had lots of consultations with different parties, those who didn't take the ideas on board. We worked with them. So these draft laws are the ones that we are proud of, but we need the support of the parliament of this legislation. We need the understanding of the members of the parliament, and this information awareness element should be reinforced, and we are going to contribute to that, and I'm sure the Ombudsman's office is going to do that too. Thanks a lot for your support. Let me give the floor to Lilia Alexiuk, who is the main or one of the main driving forces of this legislative reform. Thank you. Good morning. I have a presentation. I'm not going to put it up yet. Let me just say that summarize have their path, but don't have a goal. So we have a path, and I have been on this path for 13 years, and that's the path of improving the situation with the data protection in Ukraine. I am really happy that we have Lithuanian partners. On February 16th, they had state holidays. Congratulations on that. Diana and another expert assisted us a lot to develop legislation on digital services. These two experts understand Ukraine better than anybody else. So Lithuania was under occupation of something that is called Russia, that took over the legacy of the Soviet time for a while. So they understand us better than anybody else. They help us a lot. Thanks a lot for that. We appreciate it. They're extremely helpful when we need to explain the principles to our people. Let me just remind you of what happened yesterday. The helicopter pilot and the thing that happened to him. So it might seem that it is because of the war, but that's just because the person didn't take care of his personal data, who did not protect his data, and that's why lost his life. So privacy, right to life, and personal data protection are so interlinked, and basically that's what might happen if you don't take care of that, and that's what we need to remember about, especially during the war in Ukraine. Now my presentation. Let me just remind you where we started and why Ukraine started doing this. Association agreement was the trigger, and their first ideas were approved in 2007. And basically today we're talking about the things we talked about then. That's the necessity of establishing a dedicated authority and the necessity of taking care of these things. Now, the role of personal data protection in digital world. So to make sure that digital economy is developing and Ukraine and European markets are harmonized, we need to make sure that all these sectors that you see on the slide are in compliance with the EU legislation. And cybersecurity and personal data protection, that these are integral elements of any other sector and field. Basically, that's the basis. And then you can start building up the other elements that we need to address. Without this basis, nothing is going to happen. Now you have a tentative list of the elements from the association agreement. These are the requirements for Ukraine to meet, and all this is linked to something that would be identical to GDPR. So personal data protection covers a lot more of the elements and fields, and most of the documents that have been implemented by Ukraine and have been reported to the European Commission, and European Commission stated, that's right, yeah, we moved along this way, that's electronic communication, and electronic services. Without that, Ukraine cannot say that we have complied with other requirements and can make benefit of European market. Why do we talk about legislation? And that's 10-15% only of the things that we need to comply with to have proper level of adherence. That's not only institution dedicated to supervisory authority, that's the Ombudsman office role, that's courts, the subjects of personal data, that's businesses, that's state authorities that have to play a role in proper personal data protection. And that's the situation when we have to follow a stick and carrot policy. We know that sometimes it's difficult to motivate a person until and unless the person sees specific advantages or sanctions in case of doing or failure to do something. And that's how administrative and criminal liability in our country is structured. If the person is reluctant or unwilling to do the things the person is obliged to do as the person and citizens of the country. But we have to get engaged in information awareness, because sanctions are not going to work on its own. And judicial protection. Last year we had a study what is the situation judicial system. We don't have a single case under Convention 108. There is only one decision for the entire period of time when the law on personal data protection, only one decision. And let me explain why. So to institute a criminal case under article on violation of privacy, I have to personally go to where to police, to a policeman, and explain how my rights have been violated when my Facebook account was hacked, or when I see that my personal data were breached and are all over internet. And now the state of play. The draft law, as it was said, the Parliament has been having this law since 2021, and that's the second stage that we are going through. The first hearing lacked votes for the draft law to be approved, and we have developed the next version of it. On October 18, 2021, it was referred to the respective committee, and the committee has not considered this draft law until now, and we don't know the reasons for that. We don't know what are the real obstacles to consider this draft law at the committee, to have some kind of a position of the committee so that we know whether we need to work with the text of the draft law or what else is necessary to make it voted for. But without respective authority, they wouldn't be able to comply with the GDPR. How to establish respective authority? There are several options here. We shouldn't establish the authority of 400 persons from day one. It could be done on a step-by-step basis, and we do have the experience when it was done in this manner. it could be a bureau, an agency to start with on a smaller scale. That was the experience of corruption authorities in our country. One of the authorities was set up using EU taxpayers' monies at the initial stage. So that's the experience, that's the precedent, and it shows that that's the option to go if you don't have public funds to support it. But my idea is to have this scenario. At the first stage, the authority would take care of the issues of drafting bylaws, and that's around 50 that we need to develop to implement the law on the National Commission and on the personal data protection. Without this authority, without this stage, we won't be able to have the desirable outcome. But to have at least 50% for the authority, we need to have two competitions. First, to register the authority, and the second competition, that's to have inspectors with the competence of control. It's not many that we will need them at the initial stage, but at least 3 of them should be there. So to make sure that the authority is up and running, we need at least 4 members of the Commission to be elected on a competitive basis by the Competition Commission to be approved yet. And only that we will have the authority, unless we have independent competition. So we shouldn't even start considering establishing this authority. We need trust on the part of the community, on the part of the public authorities. We should have transparency when establishing this commission. Unless we have that, we won't be able to accomplish the goal, namely trust and credibility of all stakeholders to the authority and its mandate. Then second stage, and it could be second year, and we can reinforce the authority and train more people, because we need the experience of European countries, and they have to learn this experience. The role of Ombudsman office is actively engaged in communication with different authorities. Why? Because there are lots of issues that go outside the geographic territory of country. Internet doesn't know borders, and there are lots of authorities that have done this already, and Ukraine has to borrow this experience and incorporate that into Ukrainian practice. So why don't we consider this scenario, this option, and if it is supported, then it could be part of the final provisions. The next, the law on personal data protection of 2022. The first was the responsibility of the Committee for Digital Transformations, and we lacked votes to vote it into the law. But at the moment, the draft law looks much better than the previous text, and the situation is better. It passed through the committee. There is the decision of the committee to consider it in the first reading, given Article 116 of the Rules of Procedure, and we have the agreement that's the way it will follow. The complication here is that at every stage it is referred to the Council of Europe experts. As soon as we have any recommendations of the Council of Europe, it should be taken into consideration by the authors of the draft law. That was the story with this draft law. So we have the text of the draft law that took into consideration of the opinion of the Council of Europe experts, and it is going to be considered with all these recommendations. What is the complexity here? So the thing is that nobody will like this draft law. Never. We will never have the situation when this draft law is good for everybody, and the entire parliament would say, well, we support it fully. Why? Because members of the parliament have different backgrounds and interests. They have different knowledge and experience in personal data protection, and they have different expert potential. You see what I mean? And there is no secret there that they have different vested interests that are linked to their previous experience or potential experience. Politicians, we have to admit that when I hear that national interests are going to be considered when discussing these draft laws, it's not going to happen. Just forget about that. Because so we have to follow one option, either GDPR as it is, or there is no any other option. It is us who are aspiring to be EU member states. So we have to fully accept GDPR. High fines, okay, if it were the case that we were EU member state, then we could determine only the exchange rate to pay fines in the national currency. That's the only option that we have here. That's the only option that was used by the EU member states if they didn't have any currency. For instance, Bulgaria. So that's what they did. So they have the exchange rate for them to pay the fines in their currency. That's the only thing we can do. All the other things are not going to be considered anyways, unless they fit GDPR and 108 plus convention. If that's a deviation from the spirit, not from the letter of GDPR, it's not going to be taken into consideration. So as soon as the first reading is passed, that's just the start. Then Council of Europe experts will look into the text ready for the second reading, and then either we'll have the green light or not. The European Commission is going to consider the opinion of Council of Europe experts only, because that's the best experts. So that's the experts of the experts. So that's our path. We are on the path to EU, and we have to follow that. So there was an option, okay, why don't we translate GDPR and incorporate as it is? But we have Ukrainian context, so what we need to do is just incorporate what GDPR is into national legislation, because we have the entire section of the personal property rights that provides for some personal data procedures, and we have to consider this and some other elements. So that's the answer to the question why we are moving slowly. So we don't have the date, but the first draft law is there for consideration for the first reading. What is new in the area of the personal data protection? Yesterday, I had doubts as to whether I should include this slide, but when I checked my personal data, I decided to keep it. On your left-hand side, you see all the chat boards where your personal data can be found. The only disadvantage is you need to add your phone number. So in my case, the situation is much worse. I am PAP and I cannot object to personal data protection because I am a public person with all the implications, economic, personal, and moral to this. The situation is getting worse. The number of attacks that lead to the personal data breach has increased. And the number of those who are ready to talk about that honestly has decreased. You don't see the year, you see just the names of the companies. But let me just tell you that that's the outdated data, but the relevance of them is no less to this end, because many people do not change their email addresses, they do not change the personal ID card, passport numbers, and doesn't change the contracts with the communication officers. Well, that's really important data that you see here, because, well, one of the contracts is just the contract between me and Kyivstar telecommunication company, and it's only them and me who knows the number of the contract, and the situation is getting worse. The EU cannot imagine this chatbot in the Telegram that I showed on the slide. When I go to Google, I cannot find so much personal data, because if it is the EU, then Google says, okay, sorry, but that's GDPR protected, and I won't be able to find any data except the ones that are publicly available in media. But there is a huge problem in Ukraine with that. On your screen, you see the slide from last year. Last year we had a conference in Poland where we discussed these issues. Euro for Digital organized this event. They had a huge conference, and we shared with the Europeans our vision of personal data protection in Ukraine and our future here. As you see, we are lagging behind again, and you see that the possibility of implementing everything that is needed for proper personal data protection is huge. If we start now, we will be able to finish in 2031. So what's going to be sooner? The agreement for proper level of protection, if we agree to that, or we join the EU, and then we'll have to quickly do everything, but I don't know how we'll manage. We'll probably fail, because the first competition to select commission that will select members of the respective authority will take 6 months, then 6 months for the members of the authority to be elected, then the commission for the inspectors. So we will need 18 months to set up the authority, and then we will need the time for the authority to start being operational. Victoria was mentioning that, and the Council of Europe experts were mentioning that too. Here is the report of the European Commission, and there are 3 mentionings there about the personal data protection. Not once, but 3 times they mentioned personal data protection. I don't know what should happen, what else should happen for the Parliament to consider this and start doing something with both draft laws, because the last sentence says that the European Commission knows that Омбудсман is an excellent authority, but that's parliamentary agent, and there are advantages and disadvantages there. And summary, where just small recap. There is no chance for national specificities in implementation here. Ukraine is a signatory of both Convention on Human Rights and 108 plus, and we need to set up authority before, not after, because the time frame is limited. And we need to meet the mission and goals of the convention and additional protocols. So the draft laws should go together as a package, because that's the basis for the personal data protection. I would like to repeat that that's a litmus paper to show the desire of Ukraine and aspirations of Ukraine to join the EU. I am really grateful that Ombudsman of Ukraine, despite the limited mandate, is doing a lot to this end. Recently, I was commenting on this, and I had to admit that the role of the Ministry for Digital Transformations is huge here, and I'm grateful to them because they bear the burden of doing everything of personal data protection, though it's not part of their mandate. But unless we have a dedicated authority, then automatically all the issues go for the Ministry of Digital Transformations to take care of that. But actually, it is Ministry for Digital Transformation that creates the highest risks for cybersecurity and personal data protection, because the digital transformation is the most risky area for cybersecurity, and personal data protection is an integral part of that, and that's recognized by all countries. Thank you for your attention. Let's start the discussion. But if Alexander Burmagin is here, then I would be happy to give floor to him. Lila took all his time, but if Alexander is still there, I will be happy to hear you. Good afternoon. Apologies for keeping you waiting. Alexandra represents the National Council of Television and Radio Broadcasting. Alexandra had been working in media sector for a while, drafting legislation on access to public information, and at some stage we agreed that Ukraine needs the authority that would combine the mandate of protecting personal data and providing access to public information to save money and to make the respective authority efficient. Over to you. Thank you. I'm happy to see familiar faces. Unfortunately, due to business trip, I'm not in Kiev. I would be happy to be there and participate in the event offline. As to the design of supervisory authority, I'm still supportive of this idea, though we know that there are diverse opinions and somebody supports the combined role of protecting personal data and protecting access to public information, and doing this by one authority. Some colleagues believe that there are high risks here, and they believe that if it is a supervisory authority that would take care of personal data protection, then that might prevail over the access to public information. But anyways, I believe that this authority should combine both functions in one body, and there are lots of arguments to support this. But let me start with the discussion, actually. I was listening to the colleagues, members of the parliament, Lila and Council of Europe experts, and since I was and is in charge, because National Council for TV and Radio Broadcasting is in charge of TV and radio reform, media reform, there are lots of resonating issues, and we sort of a twin reform, because what is happening with the draft laws on personal data protection and our reform in our sector are sort of similar in a way. And a few words about our history of reforms, because they are very much similar. And why I am so optimistic, because indeed we are the path to EU membership, and it's very important at the political level of the state. It was identified as the priority, and whatever administrative bureaucratic processes are involved, that's a priority there. And to answer the question Lilia raised, what else is needed for the parliament to start doing something on that, given the experience of media reform? So the political will is there, but there should be a direct kind of, recommendation of the EU. Then everybody will do that. The parliamentary committee, president's office, everybody will be doing that. We'll see that everybody will check in whether the requirements are met. The law on media immediately started moving when the necessity of its adoption was on the list of the requirements to become a candidate state. When it comes to screening of our legislation, I think that's going to happen to these draft laws, and I'm sure that's going to happen on personal data protection legislation as well. 90%, that's my assurances for you, and I'm sure this reform on personal data protection is going to be there, because the personal data protection rights are cross-cutting things, and Lilia was saying that it is the banking, media, all other sectors that are part of personal data protection. So that's European integration process, and I think that's important to remember. We undertook our obligations back in 2014 to implement the best standards in personal data protection realm, and that was done in the association agreement, and all reports on the implementation of the association agreement, this element is covered. European Commission report mentions this clearly too. That's why I'm really optimistic that soon this process is going to be on the proper track. Taras reconfirmed the support. Alexander reconfirmed their support. My colleagues from our line committee on humanitarian and information policy, Evgenia Kravchuk, wanted me to tell you that we support in our committee this reform too, and the only thing is they need to balance the interests of personal data protection and freedom of expression, dissemination of information, and rights of journalists, because a long time ago when drafting these two laws there were some issues that cropped up, but following the expert opinion of the council opinion, and we know how professional the experts are, because we had expert opinion of Council of Europe in our reform. I'm sure that we are not going to face the risks that we had before to the things I mentioned in the new draft laws. Lila spoke quite at length about these things. Let me just underscore several things. When the law on media was voted for, I was sure, okay, so finally we got it. So the reform has been done. But let me just mention you one important thing, that just the beginning of the path. That's 1/3 of all the work that should be done, because the adoption of the law on comprehensive systemic reform is just 1/3 of the things to be done, because implementation of these standards, launching the respective mechanisms, developing the bylaws, and Lila mentioned that too, that's exactly what we need to focus on, and that's what we are doing with respect to media reform. And that's huge resources that are needed, including human and expert resources. That's the task for years to come, and that's why we needed to adopt these laws as quickly as possible. That's another argument to support this, because that's a time-consuming process. That's a lengthy process that would take years. Well, in our case, we are going to take a look at what has happened in the course of 1 year. There was a lot of different things done, but there is a lot to be done yet. And we need to remember that media reform had a little bit better situation because there is a national council, a kind of long-standing regulator there. They had staff, they had experience, they have a history of being a regulator. So what we did just expanded the number of subjects that are governed by the body. But with personal data protection, the regulator, the supervisory authority is set up from scratch. Lila spoke about that. I'm not going to repeat that. So that means it's going to take a lot of time. I'm very optimistic. Let me repeat that again. Without implementation of these standards, Ukraine, is not going to be a member of the EU. So I think that's going to be evident to everybody. Our rules are very outdated. We lack the supervisory authority. That's why the accountability for the breach of personal data is very illusionary. So that's not the approach for the EU. So nobody is going to have us there unless we remedy this. We have to start. We have to start working on that actively, having listened to members of the parliament, having talked to the members of our parliamentary committee. I think we need to start actively working with the parliament. It should be lobbying, education, information awareness. That would speed up the process in the parliament. Thank you. Thank you, Alexander. Thank you for the inspiration. I think we are on the European integration path. The only thing we are waiting for is for the members of the parliament to be more active. I do understand that everybody is a bit tired, but let's just dedicate 15 minutes at least to exchange comments as to the future of the process. You represent different state authorities, so for us it's very important to get your intake for the expected new things. Alexander Shevchuk wants to say a few words. Sergei, we need members of the parliament to support us. Thank you very much. Good afternoon. Let me thank Омбудсман Office and Council of Europe for organizing this event. As to the draft law 8153, let me just say, as representative of the Committee of Digital Transformation, we considered it in October 2022. We support this draft law, and most of the members of the committee, or maybe even all members of the committee, support it, and we are ready to vote for it in the parliament, and we're looking forward to this chance to vote for it. As to the draft law, when considering it, in our official opinion, we stated that extremely important draft law, it should be voted for, but there are some comments as to the terminology, definitions, the procedure for processing data, so there is room for improvement there, but all these things can be done and improved before the second reading. The draft law pays a lot of attention to intentional or undesirable challenges, the procedure, how the person can report this to law enforcement agencies in case of the phone calls, how to block the phone calls, but the draft law doesn't give the definition of what is undesirable telephone calls or abuse of telephone communication. So this should be remedied, and it is possible to do before the second reading. As to advocacy, I wouldn't call it lobbyism, but advocacy of promotion of the draft laws, we need the support of the experts, the support of the Ombudsman Office and the Council of Europe. We have representative of the President's Office. It would be really important if the President office is engaged in promoting these draft laws, because not everybody understands how important these draft laws are, and not everybody understands that we cannot become a full-fledged member of the EU unless we adopt these laws. And one final thing, personal data protection is not only about the civil part of our life. That's to some extent about the military field as well, because modern war is not only at the front line, but that's in the cyberspace as well. And the enemy is seeking to get personal data of people living on the temporarily occupied territories, the personal data of the servicemen or their relatives. With this information, the enemy will have the leverages of influence on specific persons, including those who are decision makers. That's additional element of influence that could cause serious problems for us. That's why personal data protection amid the cyber war is critical for Ukraine, and this draft law should be approved as soon as possible. The parliament focuses on the things that are war-related. That's conscripting, IDPs, other things, and we do understand the reasons for these priorities. But since personal data protection is military-related too, I believe that this draft law should be a priority too, and that's also an element of our European integration. That's why we need to do everything possible so that this draft law is submitted for voting earlier than it was mentioned today. I think there are chances for that. As to the second draft law, I don't know why it has been sitting there since 2021. The opinion was provided by us with several recommendations, but we never said that it should be approved or anything like that. We support all the initiatives, and let's work together on that.
Do you want to add anything? How are you going to form this coalition after today's meeting, if it is possible at all? Can you influence the parliament? Well, in fact, the situation is such. Why did I speak about summertime? Because we have more relevant issues on our agenda, more emotional issues related to life and health of people. And here, this is the issue about information. And if we can get enough votes, I have heard my colleagues, I've heard about their support. I think that we will just, apply to the chairman of the parliament, because he, as the first author of the draft law on personal data protection, would initiate putting it on the agenda as a priority bill. That's the maximum we can do now. And then there will be awareness raising, and I'll work with the colleagues, the ones who understand what personal data is, in order for them to convince the other colleagues that the subject matter is very important. Thank you. Thank you for your support, Alexander. Thank you for giving me the floor. I'm one of the drafters of two laws that we're discussing here, and I'd like to make a short comment about two aspects. First of all, why it's extremely important to adopt those draft laws in the nearest future, and why GDPR is not only our future. We often speak about that as our future, but that's our today. First, as many experts of the Council of Europe have already said, the roadmap for personal data protection is the Convention 108 Plus and the GDPR. So the GDPR according to the rules of the European Union, is a direct action act, and it creates a binding circle for all the 28 member nations. As the strategic vision of the country is that we will definitely have to become an EU member, a part of the digital market, a part of that legal field in terms of personal data protection. So we have to draft those two laws. Another aspect, we often say that we have to enhance the system of personal data protection system. According to the laws, system would always mean two aspects. First of all, that's the legal field, the legislative framework, and second is the implementation mechanism. In other words, who will implement it in practical terms. And that means that, like in all the EU member nations that have had it since 1995, a supervisory authority in personal data protection. Why GDPR is not only our future, but it's our nowadays. According to its rules, GDPR is an extraterritorial act with extraterritorial action. It already works for the Ukrainian businesses under certain rules. If Ukrainian companies work, for example, with the EU member nations, if they deliver goods to them, deliver works, provide services to them, if a Ukrainian company works with EU citizens and the Ukrainian companies have their affiliates, say in the EU, and if they do monitoring or marketing work in the EU member nations, and a number of other aspects, that is related to banking, telecommunications, tourist companies, medical business, and they are huge taxpayers during the war. And according to GDPR, they already should step their internal company rules in accordance with that regulation, create all proper mechanism, train their staff to have internal documents and technical means for personal data protection. We have to support Ukrainian businesses so that on the legislative level, we would have the framework that will be harmonized, that would meet the best practices and standards of the European Union. And the last thing, many people in this room, many experts of the EU and the regulation says that mostly the GDPR is about protecting people, the subjects of personal data, to protect each of us. It starts with protection of individual rights in terms of our information and our knowledge of who possesses, who manages our personal data. And here awareness raising is very important. In parallel with the process of adoption of the legal acts, we have to raise awareness for businesses, for public authorities, and for all of us who are subjects of personal data in this area. And a very important role is played here by the Ombudsman's office, by the Ministry for Digital Transformation, the Ukrainian office of the Council of Europe, for digital, many NGOs that are already taking certain steps in order to bring us closer to the implementation of those legal regulations that I hope will be adopted by the Parliament in the nearest future. Thank you. You practically drew the line to this event, by underlining the importance of the GDPR. If you have any more ideas, please speak up. If there are no ideas, then I suggest, you have some, good. Introduce yourselves, please. I just can't see. Danila Kloba, co-chairman of the Committee on Personal Data Protection, American Trade Chamber of Ukraine. I want to say that we completely share the need to introduce mechanisms for data protection in Ukraine. Clearly, we have obsolete legislation about that. And in general, I think by some 80%, we know practically everyone who has been engaged in this process, all the stakeholders. At the same time, I cannot but say what expectations businesses have about that, in particular as regards the regulator. Well, I see that everyone is very happy about the idea that there will be an authority, and that would be about training and about, but we have never seen any regulator in Ukraine would first speak about training rather than fines, and the fines are huge. In that case, we do not exactly understand why we should have a separate legal regulation with such specific powers in terms of sanctions, but not just like all the other regulators and supervisory authorities. Okay, this is European practice, but the convention, the agreement, the EU-Ukraine agreement, speaks about introducing the best practices and not just copying them, but introducing them in the Ukrainian reality. And it shows that the more powers an entity has, the more corruption risks there are. And let me remind you that as corruption-related factors have been discovered, the previous draft law was not passed. There is another thing here is the legal certainty as part and parcel of the rule of law principle, because every entity should be planning its behavior. In this situation with personal data, the situation is such that there is not a very big specificity of what it is. The constitutional principle is not adhered to. Of course, European practices are somewhat different, than Ukrainian ones. So what we need to do is to say very, very clearly and specifically and how an entity can be identified and how one can model one's behavior if one does not know what responsibilities would be. We now see the financial monitoring situation, which is very similar. When the borders are very vague of those definitions like risks and so on, and we see as a result that very many decisions of the National Bank and of other regulators have been quashed by the courts because of their legal uncertainty. And especially in the period of the aggressive war, we see such negative phenomena as the growth of corruption. And those things should be overcome as a result of transparency, so that the information that would be proclaimed, and we had some changes back in 2015 in terms of access to public information, access to registers, so we would not have information where the eggs would cost 17 hryvnias each and many more things that we do not yet see. At the moment, the registers are being closed, and we have very little information. For example, very many data sources have been closed down in the area of taxation, and if the regulator, as it is planned, is going to take care of personal data and public information. So there is a certain conflict, conceptual conflict in this work. Because although this is one area, an information area, but the zones of interest are different. Because personal data is about protecting information with limited access, while public information and open data, that's open information. There is a conflict here. And in the draft, we have discussed it, they speak about such things that it is impossible, for example, today, for example, one can do anything that is not prohibited if this is the objective of the law. For example, we can take information from public registers and make it public. And this would promote transparency of business, of the civil society development, and provide protection against corruption, for example. In the future, this may not be accessible because one should have proper grounds to use it. And that can mean that the information will be closed. The so-called Yanukovych case can be, in fact, repeated. Yanukovych can say, why are you sharing my data? I'm also a human being. Thank you very much. I really respect your point of view. I'm just not ready to hear so many things about corruption because I think that a lot depends on us. If we want to create a normal authority and to somehow, take a new road toward corruption, like all of us in Ukraine, so that we would have no more expensive eggs and things that we are stuck in. Lilia said correct. Okay, let's create an authority where everyone would understand what it deals with. I think that our businesses are ready for such. Fines have been ready for them because they've been using this GDPR at the national level for quite some time, but maybe not in such a scale. So let's talk probably less about corruption, but more about real cases. I respect your position. You correctly named those risks because of the situation in which Ukraine finds itself. But of course, we wouldn't want to keep carrying out this load of corruption. We would like to become a normal country that would join the European Union, that will win this war, and with a new, fresh, renewed Ukraine, a young Ukraine, with a new authority, a new kind of business, with new rules. I agree with everything you've just said, all of your ideas. What you said is quite visible, but let's think positive. I would very much like to have something different than what we have today. Taras? I'd like to add that if we want to set up an authority, we have to start with ourselves. You've just forgotten to say that you are also the owner of UA Control that sells data, so registries that are closed is something that diminishes your profits. There should be some balance. It is possible to trade in data. That's illogical, but of course, if there is consent of the people. And what you're saying here is that it is important that some data about PEPs and about officials would be open. I agree. I completely for openness of the authorities, of the government, but I'm for being honest as well, so that we would honestly say what we are lobbying now. We're going to be discussing the law lobbying and next week, and such issues would have to be regulated by it. Thank you. The very last comment. Just wanted to say that as a person who has been for 33 days under occupation in Hostomel, my family was just saved because nobody knew who lived next door to them, and nobody betrayed us. Nobody told the occupiers, or else we would not be talking about that here today. Sometimes privacy has the key meaning, and I, better than no one, know that, from my own experience, because they did not come to our apartment, because they just didn't know what to look for. If they had known that, then not a single member of my family would be here, neither are people living next door to us. So let's be sincere. We are now in a situation where we can start from scratch, all of us, rather than talking about corruption factors, corruption risks, corruption-prone authority, without ever trying to even put a member of your organization into that authority, into that entity that will take care of open data, of public information, trying to find that balance between confidentiality and openness. Thank you. Can I make one more comment? Yes, please. Alexei Kabanov. I'm also a co-author of those draft laws. I was more engaged, of course, in the work on the National Commission, that draft law, and I represent a part of the group that is related to access to public information. Within the context of those problems that are related to limiting access to public data, let's call it like that, we have a problem not so much within the context of how this law on personal data will be adopted, but rather the failure to implement the current laws on access to public information by information managers. They're difficult to implement. they're under-regulated as regards the area of non-personal data. The EU, when it adopted GDPR, it started working in parallel at once on the regulations that regulate the area of non-personal data. 1807, 868, Directive 1024, that are exactly related to access to non-personal data. And within this context, when we speak about this huge area of non-personal data, and that's economy, that's the data that one needs for functioning of different digital services, for development of digital economy, this is impossible without GDPR, without implementing GDPR in the national legislation of Ukraine. That's why, even if we start speaking about some kind of digital economy, integration into the EU, into their digital economy, we first have to implement the GDPR and then in parallel start working on all those new regulations of theirs on non-personal data. And it is very, very important why we should collect our thoughts now and adopt those draft laws at the current stage, because there is no time or space to procrastinate. We can delay that again and again, but these are very important bills that have to be adopted. We've discussed the format of them, the design format, but the current draft laws would be sufficient. They have been sufficiently developed. They have taken into account many comments and recommendations from various institutions and private organizations. I think it should already be voted in the parliament. Thank you. I think the time has come to put an end to this meeting because, dear members of parliament, and I'm very grateful to you for having stayed with us during all this event. Thank you. That's a record, in fact. With your support, I hope that we will be able to get this positive result, that the law will be among the priority lists, especially as regards the Euro integration priority laws. As regards the Council of Europe, we are ready to keep participating in further expert work together with the Ombudsman's office. So we will be knocking at the doors of all the public authorities that would be interested in cooperation. And I wish us all success in this Euro integration, along this Euro integration path. Glory to Ukraine. Thank you.